Good morning, everyone, and welcome to ICG's Digital Academy webinar series. I'm Sally Alsop, the ICG committee member responsible for running our webinar programme. Apologies for the slightly delayed start, but we're just running a few minutes late, so I hope that's not too much of a problem. So for today's webinar, we're delighted to welcome Suzanne Dibble. Suzanne is a multi-award-winning business lawyer who's advised multinational corporations, private equity-backed enterprises and household names on billion-pound projects. Since 2010, she has focused on helping small businesses with their day-to-day business law requirements. She combines her knowledge of large organisations with a deep appreciation for entrepreneurship, especially online businesses, to provide practical and relevant advice. Suzanne is the best-selling author of Gdpr for Dummies, following the success of her Facebook group, Gdpr for Online Entrepreneurs. I think many of us took advantage of that when GDPR was looming fast for us. In this group, the largest social media group, which grew to 40,000 members within 2 months, on the topic of GDPR, Suzanne has been able to help tens of thousands of small business owners, charities and organisations from around the world via her numerous video guides, online training sessions and live Q&As. As usual, at the end of this session, there will be a Q&A, so please type your questions in the question box as we go along, and I'll read them out when Suzanne's completed her presentation. We're really grateful to Teneo Translations for sponsoring this webinar. The owner, Chris Barella, is an ICG member. Teneo is able to handle any size translation or interpreting assignment into any language and has broad experience of the market research sector. Before I hand over to Suzanne, here are the next webinars to note down in your diaries. Don't forget that we're able to offer great value sponsorship opportunities with each of our webinars. Sponsorship normally costs £100 for a lot of exposure on our website, mailers and social media, and of course on the day. So please contact Lucy if you'd like to know more. So our speaker today is Suzanne Dibble, and I'll hand over to Suzanne. Suzanne won't be presenting any slides today, but you'll have the benefit of being able to see her live during this discussion. So I'll just hand over to you, Suzanne.
Thank you for having me. Can you hear me okay?
You should see a little box that appears on your screen so that people can see you.
It's saying main screen, show my screen.
Yep.
Show my screen. Is that going to show my what I've got up in the background, maybe?
Hopefully it should show you. Oh, no, we've got go to webinar, so we need to, yeah, that's perfect.
Okay, just like that?
That's perfect. I will put myself on mute and then over to you.
Okay, well, fantastic. Thanks for being here. Thanks for inviting me to talk about this key area. Yes, apologies to not have any slides. I was actually in bed with excruciating headaches, which I can only imagine is a reaction to the homeschooling and a signal that the kids do indeed need to go back to school ASAP. So you've got the pleasure of looking at my face instead of the slides. I'm not entirely sure how much you know about GDPR. Hopefully you know an awful lot and you're all fully compliant, because obviously it's a law that came into force on the 25th of May 2018. Saying that, I would not be surprised if you're not compliant. I think there was a survey done in terms of small businesses and their compliance, and it came out to something like, I think 20% were maybe fully compliant. And the good news is that, you know, really there are a few key things that you need to do to stay out of trouble, which I think, you know, on the budget that small businesses have, is a good place to start as any. It was funny, when I started my Facebook group back in February 2018, I had people coming into the group saying, oh my gosh, I'm going to have to close down my small business because I don't have the budget to instruct a lawyer to come and check all of this out for me. And, you know, if I'm not compliant, I'm going to be fined 20 million euros on the 26th of May 2018, which is the day after it came into force, and 20 million euros obviously being the maximum fine. And I had to really reassure people that that wasn't the case, that there wasn't a vast data protection police force that would be going around checking that everybody was 100% compliant and about to levy a fine of 20 million euros. As we've seen over the course of the last 2-3 years, well, nearly coming up to 3 years in May, the fines have been reserved for very serious breaches of the GDPR, and the significant fines are going to people like Google, or people who are doing real-time bidding, or part of the ad tech, big data, monitoring behaviour on a serious level. I'm really yet to hear of a significant fine for a small business owner, so hopefully that should reassure you. However, saying that, that is not a reason to put your head in the sand and to ignore that GDPR exists, not least because consumers, your potential customers, certainly businesses, if your business customers, they are becoming much more savvy about GDPR. They're becoming much more savvy about their rights in relation to that, and they're becoming much happier to report you to the Information Commissioner's Office if things don't go as they should do. And also competitors are getting wise to this as well and are reporting non-compliant competitors. Equally, we're seeing a rise of privacy activists. I had a client on the phone the other day who'd received a letter from a privacy activist saying that they hadn't had the right wording on their cookie policy. Well, they weren't cookie, they actually weren't cookie compliant, as they are now. But because they had been tracked on Facebook and the privacy activist hadn't consented to that, they had written to them and were claiming, I've had a number of these cases now, anywhere between £600 and £2,000 for breach of GDPR rights effectively. So we're seeing a rise of those kind of letters as well. We should want to comply because it's good practice to look after people's data, to make it secure, to make sure that we're not doing with it things that people don't expect us to do with it, etc. It's all coming from a very good place. It's all very good practice. And I think what people get hung up on is the how to implement it, and they get caught up in the complexities. What we need to do is take a step back and look at the overriding principles, which I'm going to go through as a reminder now, and then I'll come on to the specifics of your industry and what you need to be thinking about. Okay, so the overriding data protection principles, they aren't really anything new. When GDPR came into force, these were pretty much already there in terms of our existing data protection regulation, but I was amazed at how many small business owners had no clue about data protection. They didn't even know it existed. It was only really with the media attention that the GDPR was given because of the increase in fines that data protection even came onto the radar of many small business owners. So it's always worth stepping back and reminding ourselves of the data protection framework. So there's 6 main data protection principles: lawfulness, fairness, and transparency. And what that essentially means is that you can only process data lawfully and if you have lawful grounds to do so. And consent is one of those lawful grounds. People make the mistake of thinking that GDPR is all about consent, and that's not the case. Legitimate interest is another ground that many people have heard the expression but don't really understand what it actually means. And then you've got contractual lawful grounds of processing, which many people overlook completely. If you need somebody's name and email address and home address to send their goods to, then you don't need their consent to process that data to do that. That's a contractual ground of processing, because without that information, you can't fulfill the contract. So that's the first one. Lawfulness means you've got to have the lawful ground of processing. And there are 6 lawful grounds, which I won't go through them all right now. Fairness and transparency means that, well, the fairness side of it means that you'll only really do what you say you're going to do with the data, and the transparency side of that comes from what you put in your privacy notice, and that is your public-facing GDPR document, if you like, and it's the easiest thing to get right, and it's the the most likely thing to get you in trouble, because it is that public-facing document. So if a savvy prospect or a savvy customer or a savvy competitor sees your privacy notice and sees that it's not GDPR compliant, or that you've not updated it for Brexit, for example, then that's an easy way into you. It shows a lack of, it's a very obvious lack of compliance. So that's the first thing that I would encourage you to look at. Ensure that your privacy notice is compliant, that it's in all of the right places at all the points that you're collecting data, and that obviously you've updated it for Brexit. So that's the transparency side of things. And there's, if you didn't know, there's about 14 things that the legislation actually mandates needs to be included in that privacy notice. So don't try and cobble your own together. Definitely don't copy them from somewhere, because that could get you sued for breach of intellectual property rights. And if you are if you don't already have a compliant one, or you maybe did cobble it together, I'm going to be telling you at the end how you can get hold of my GDPR template pack that will help you with that. And again, similarly, if you don't know how to update it for Brexit, then you might want to look into it for that purpose as well. Although I'll come on to Brexit more towards the end and explain how things have changed. So the second principle is purpose limitation. And what that means is that you can only use the data for what you've said you were going to use the data for. You can't collect it for one purpose and then change your mind and use it for something else. So I've got a free challenge running at the moment. We're promoting it. It's running from the 8th of March for a week. And we are collecting that data for the purpose of the challenge. Now, if that's all I said on the privacy notice, we're collecting the data for the challenge, and then I changed my mind and thought, oh, actually, I could sell all this data and send it to XYZ Limited, and they'd give me £5,000 for it. Now, obviously, that is not compliant with the principles of GDPR, nor is it fair or transparent. So, oh, there's my daughter in the background there, just wondering what I'm up to. The joys of homeschooling. So you've got to be upfront with people about what you're doing with the data, and you can't just change your mind once you've got it. You've got to go back and look at the lawful ground of processing, reissue a privacy notice, get consent if you need it, etc. The third principle is data minimization, and what that means is that you only collect the data that is necessary for the purposes for which you are processing the data. Okay, so for my free challenge, for example, we're collecting a name and email address, because that's all we need in order to communicate with them and invite them to the masterclasses within the challenge. Now, if I, on that opt-in form, aside from the fact that it would completely decimate my opt-in rate because people don't like providing that information, but if I ask them for war and peace about their life or even their business, then clearly that is breaching that principle, because I don't need that data for those purposes. Now, that's not to say you can't segment your audience, because you can. You just need to be upfront about what you're doing and why you're doing it. So I could say on that challenge form, I could say something like, we've got some great free bonuses that are dependent on what sector and size of business you are. So please fill in the following form to tell us what size of business you are, what sector you're in, how many employees you've got, etc. Okay, and again, if I only use that data for the purpose that I've told them about it, then that's all fine. Okay, but you just got to remember, you've got to be upfront about what you're doing with that data. You get as little data as necessary for that purpose, and if you want to expand that scope or expand that purpose, then you need to go back and revisit the whole thing. The next principle is accuracy. So there is a duty on us as data controllers to ensure that that data is accurate. Now, how do we do that is a question. People have given you a name and an email address 3 years ago. How do we ensure that that is up to date? And obviously, what we need to do is either, if we're larger businesses, we might have a privacy centre where people can log in and keep that information up to date. Otherwise, we can send them regular reminders and say, maybe every 6 months or something like that. This is the details that we've got on file for you. Let us know if if there's any change. Make sure you're sending it to the right person. If you do it that way, you might just want to do a general sort of, has your information changed recently? Please let us know. But that is what we're supposed to be doing. And obviously, this is really important with people that are selling lists, or your recruiters in your industry, to make sure that that data is accurate. And I'll be coming on to the due diligence that you need to be doing on data that you're getting from recruiters in a bit. So storage limitation, again, you should only really be storing that data for as long as you need it. You need to think about retention policies. So, if you've got recruiters that are giving you lists that are, maybe 5 or 6, 7 years old, you need to be asking some serious questions about what was communicated in terms of retention periods. Okay. And finally, really importantly, the principle of confidentiality and security of data. And this is where we're seeing the most fines, and the most significant fines have all come from data breaches. Okay, so if you've got a big project on and there is a big database and somehow that ends up onto the dark web, and what depends what data is in there specifically. Obviously, the more sensitive, if there's any financial details or anything like that, then that's a big issue. But your security needs to be proportionate to the risk, and you need to be thinking about not only your own security, but the security of people within the chain of the data flow. So your recruiters, the client, everybody within that chain of the flow of data, you need to be thinking about security of that data. So that's just a little recap on the general principles. So let's talk specifically about your situation and market research. So obviously, if you're contracted by, say, ABC Limited to carry out a research project, and in the scenario where you're finding the data subjects yourself, then obviously you will be processing personal data, because you'll have names, you'll have an email address. Well, I say obviously, sometimes it might be anonymous data, but do be careful. There are rules around anonymization and pseudonymization of data. I've not got time to go into that on this session. I would suggest that a good place to go to is my book, GDPR for Dummies. There's a section on both of those, but it's not quite as straightforward as you might imagine. So if you are relying on anonymization or pseudonymization, then make sure you are following that to the letter, or there could be some repercussions of that. So let's assume we're processing personal data. It's not anonymized. You are a data controller, and as is ABC Limited, your client. So you obviously need to think about the collection of the data, and you will need to be providing your privacy notice at the point of collection. And obviously you need to have really thought intelligently about what's in your privacy notice, in terms of making sure that you've got those sort of 14 mandated things in there, but also really thinking about what you're going to be doing with that data, especially if you're hoping to collect data not just for one specific project, but going forwards, then you need to be really careful about being able to accurately describe what you're going to be doing with that data. Okay, it's very difficult to have a sort of all-expanding or expansive purpose that lasts in perpetuity. Okay, you've got to be very careful to be specific about what you're going to be doing with that data going forwards. As I say, make sure you've got a privacy notice in place, make sure it's updated for Brexit, and make sure it's compliant. Now, so that's the point you're collecting the data, and also make sure that you're clear on your lawful grounds of processing. If that's, I think typically, well, it's typically going to be consent, I would imagine, with what you're going to be doing with it. But satisfy yourselves on the lawful ground of processing and document it, because another overriding principle of the GDPR is accountability. What that means in summary is keep detailed records of everything that you decide to do, so that if there is any investigations, you can satisfy that principle. So obviously there will come a point where you need to there may very well come a point where you're handing over that data to ABC Limited. Maybe at this point you might do an anonymised or a pseudonymized report for them, but I imagine there will be certainly instances where you're handing that data over. Now, if they wanted to do something that requires their consent to do so, then you will need to obtain that consent on their behalf by naming that individual client. Okay, so say for example they wanted to do market research, and then for their top prospects, once you've done that market research, they want to do some outreach to them, do some email marketing, then that will need consent. So you would need to have that specific consent at the point of collection, naming that individual company in order to be able to do so. Okay, you can't now have that kind of generic tick the box of please tick here if you're happy for us to share this data with carefully selected partners. Okay, that's not sufficient. You need to actually name the data controller that's going to be relying on the consent going forwards. So if you do share that data with ABC Limited, you're both data controllers, and so you need to be thinking about putting into place a data sharing agreement. And you know, there's some really useful notes actually. I don't think I've got time to go through it now, but there are notes on the ICO website about what should go in a data sharing agreement. Obviously, you can do it the easy way and buy my template pack, and that's got a data sharing agreement in there. But do have one in place. It all goes to the accountability principle and sets out the understanding between the parties as to what can and can't be done with that data. So yeah, I'm not going to go through that in detail, but if you look on the ICO, the website is ico.gov.uk, and if you look at the data sharing code of practice, there's some really useful guidance notes as part of that. So do have a look at that. And then there's also the issue of whether you need to carry out a data protection impact assessment. And again, there's notes on that as part of the data sharing code of practice. But the ICO do recommend that if you are sharing data, that you do carry out a DPIA, even if you're not legally obliged to carry one out. It helps you assess the risks in your data sharing and determine if you need to introduce any safeguards. And obviously, if you are dealing with sensitive data or special category data here, so things like health data, data about racial origin, sexual orientation data, political persuasion, religious views, things like that, then a DPIA would absolutely be in order. So again, you can look at the notes on that from the ICO website, but I just wanted to flag that might be something that you need to do. And then also a note that you would want to look at is sharing personal data in databases and lists. And this is not only relevant if you're sharing a database with your end client, but also if you're using a recruiter and they're handing over a database to you. And what this sets out is that they make it very clear that it's your responsibility to satisfy yourself about the integrity of the data supplied to you. So if you're using a recruiter who hands you over a list of people, of data subjects, then you're responsible for compliance with the law for the data that you receive, and you have to respond to any complaints about it. So they give you suggestions of the appropriate inquiries and checks that you should make, including confirming the source of the data, identifying the lawful basis on which it was obtained, checking what individuals were told at the time of handing over their data, verifying details of how and when the data was initially collected, checking the records of consent if you're relying on consent, reviewing a copy of the privacy notice that was given at the time of collection, checking that the data is accurate and up to date, and ensuring that the data you receive is not excessive or irrelevant for your needs. And then it goes on to give a few more suggestions, but do have a look at that data sharing code of practice, because there's a lot of good stuff, and it's actually reasonably easy to read and to understand. So the main issue when using a recruiter is you can't now just say, oh, thanks, I'll just do whatever, I've got this list, I'll do whatever I want with it. You have that extra obligation to really verify the integrity of that data. So what else do I need to say? Yeah, so you really do have to do your due diligence on your recruiters and ensure that they're taking it the GDPR compliance seriously. If you are, just a reminder, if you're collecting data yourself, and certainly if a recruiter is, you'd want to see evidence of this. If you are collecting special category data, the types of things I mentioned earlier, like health data, sexual orientation data, race, religion, political ideology, etc., then you will need explicit consent to process that data. Well, there's a number of, so the general rule is that you can't process that type of data unless you fall within one of the exemptions. And the most common exemption is that you've got the explicit consent of the data subject. So do recall that there is this additional level of protection for special category data. Okay, so Brexit. Brexit is, I mean, on a general note, not just GDPR related, Brexit hasn't actually made that many changes to service-based businesses. Now, if you sell goods, Brexit has been a total nightmare. If you've been either supplying goods to the EU or importing goods from the EU, then that's been a nightmare. But for us service providers, it's not been too impactful yet, because the government has, we've effectively kept all of the same laws as were previously in place. So the only things that we really need to do are look for all of our commercial contracts, and I'll come on to GDPR in a minute, but for all of our commercial contracts, if there's any reference to the EU where we wanted it to include the UK, then obviously we need to change that now to split out the UK and the EU, because obviously the UK is no longer part of the EU. That is one thing to think about, and any regulations that are listed in your commercial contracts, you'll just keep an eye on, have to keep an eye on those to make sure that those regulations still actually apply in the way that you mean them to. So as I say, there's not really been much at the moment regulation-wise that is relevant to service-based businesses that has changed, but it's definitely something to keep an eye on. Now, as for GDPR and Brexit, there are probably three main issues that Brexit has brought with GDPR. The first is that, as I've said, we need to update our privacy notice, and that is typically because we've talked about things like outside of the EU, including the UK. So we need to go through it and make sure that we're talking about the UK and the EU where we need to be talking about those. There's also been changes to, if you'd referred to the US Privacy Shield, then obviously that's been invalidated, not as a result of Brexit, that was something totally unrelated, but that needs to be updated too. And on the subject of international transfers, the main issue that we were concerned about with Brexit is that the UK wouldn't be granted what we call adequacy, which means that the EU has decided that the UK has an adequate data protection regime so that no additional safeguards are needed to transfer data from personal data from the EU to the UK. It was looking a bit iffy about sort of 12 months ago. It was looking a little bit iffy as to whether the UK would be granted adequacy, and then we would have had to have jumped through lots of hoops in terms of data transfers from the EU to the UK, putting standard contractual clauses into place and other mechanisms. The EU has now issued very recently, I think it was just last week, a draft adequacy decision. So it's looking very, very hopeful that we will be given adequacy, and that therefore we won't have to put anything extra into place in terms of data transfers from the EU to the UK. The UK government had already said that it would make the EU adequate, and we wouldn't need to put any additional safeguards into place for transfers from the UK to the EU. So we can essentially carry on transferring personal data from the EU to the UK and vice versa without any difference to the way that we were doing it before, which is great news. And then the final thing with Brexit is that if you are processing the data of people, personal data of people within the EU, so France, Germany, Spain, Portugal, wherever it might be, if you are processing the personal data of those people, but you don't have an establishment in the EU, and again, there are rules about what an establishment means, and if you don't exactly know, then again, my book has got a really good chapter on helping you work that out. It might just, so for some people, it'll just be a straightforward, no, we know we don't have any establishment in the EU. And if you, as I say, if you do process the personal data of people within the EU, you need to appoint an EU representative. Okay, and I did a training session. So as part of my, if you buy my templates, you also get access to 12 months of updates, and we have regular training sessions. And one of those training sessions was an interview with an Irish lawyer who has set himself up as a representative. And if you have data subjects in Ireland, doesn't need to be the majority, but if you have any data subjects in Ireland, then you can use an Irish representative, which you might want to do for language purposes and things like that. And I can very happily put you in touch with him. I'll say the name, it's Floor McCarthy. Just mention me if you do go and speak to him. And the reason for this EU rep is that they act as an intermediary between the EU data protection authorities and the data controller, or equally a liaison between a data subject based in the EU and the data controller. So that's the reason for it. And similarly, it applies the other way as well, so that if people are based in the EU and they have UK data subjects, but they don't have an establishment in the UK, then they should be appointing a UK representative to fulfil that same function. So as I say, you just need to make sure that you have some data subjects in the country in which you appoint that representative. So, you know, you can't, if you haven't got any data subjects in Ireland, you can't just say, oh, I'll choose Ireland. And obviously, if you had 90% of your data subjects in France, if you're doing a project to do with French data subjects, then it would make sense to have a French representative to fulfill that function. But those really are the main changes with Brexit for GDPR. And as I say, happily at the moment for service providers, there hasn't really been much impact other than reading through contracts that exist, making sure that regulations still apply, and changing any references to the EU that now need to be separated out to the UK and the EU. So I've been running for just under 40 minutes. I know I was given the sort of 30 to 40 minutes to talk, and then sort of 10 to 15 minutes of questions. So I think I'll end it there, and I'm very happy to answer any questions that you have.
Thank you, Suzanne. That was really interesting, and I think probably a very timely update for many of us. We have a few questions that have come in the inbox. So one person has said, we film our focus groups and pass the videos on to the client. We ask respondents for permission to pass the videos on for the purposes of the research and a date that videos will be deleted, but we do not name the client because it could skew the research responses. Is this acceptable?
Well, if the client isn't going to be doing anything with it that requires consent, then you don't need to name that client. So what is the client going to be doing with it?
So presumably viewing the videos themselves, but it doesn't specify what the intention on that.
Just viewing them. So is their personal data shared on the video?
Well, just by virtue of the visibility of the individual, I should imagine they're anonymized, but
yeah, okay, but they'll be able to see the okay. So in that instance, viewing, it's interesting. I mean, so really the consent comes down to when you need consent, it's really mainly about email marketing and sharing data for email marketing purposes. So if they're purely viewing the video recordings of the videos for pure market research purposes, then I would say that would fall under legitimate interests, and you would not have to name them. But what you need to do when you're relying on legitimate interests is carry out a legitimate interest assessment form. Again, there's one of those in my template pack, and you need to really what the legitimate interest test is all about, balancing the risks to the rights and freedoms of the individuals against effectively the benefit to the the person that's processing the data. So if you can satisfy yourself that on balance there is no risk, or that the benefits outweigh the risk, then you can proceed on that basis, but you just need to go through that exercise and have it documented in case there is any questions about it. But I would say that that sounds low risk. You know, it's more like if they're going to start, using it for direct marketing when that hasn't been specifically, granted for that particular company, things like that, where alarm bells start to ring.
Okay, great, thank you. So another question here. What would I need to do if I'm working as a subcontractor for a US company and conducting interviews for them using their data, i.e. they share respondent details? Some of these respondents would be in the US and some in the UK or EU and elsewhere.
Okay, so if you are, so you have to think about your role in the processing. So a data controller is somebody who can decide what to do with the data. As the name suggests, you can control how that data is used. So if you're under very strict parameters about what you can do with that data, then you might be a data processor. Really the definition of a data processor is somebody who is following the instructions as to exactly how to process that data. So if you are in that type of relationship, then you've got the data controller being the client, and then you're the data processor. Sorry, remind me of the exact question again.
What would I need to do if you're working in that situation?
So in that scenario, the US company should have put in place a data processing agreement with you, that needs to, it's a very prescribed document. Again, the legislation sets out about 8 or 9 things that need to be included in that document. And the US company should be making sure that you as a processor are compliant. And because there is an obligation on data controllers not to work with processors that aren't compliant. But obviously that's for them to do. But from your perspective, as a processor, you just need to realise that you have liability now under the GDPR as a data processor. So you absolutely need to think about security and be, I think that's the main issue for processors, and where we're seeing fines for processors is on lack of security. So that's one big issue. But yes, it's the general duty is on the controller to put that agreement into place, but there have been instances of fines for processors as well. Okay, so if the US company hasn't come to you with a data processing agreement, then you should really go to them with one. And again, there's one of those in my template pack. So that's the main contractual framework that needs to be between you. And that contract says that if you were then to go and subcontract that further, that would need to be approved by the US company. So you can't then sort of go and make sub-processors without the consent of the US company.
Just one more question on that. I mean, you referred to the need to appoint an EU representative. In that situation, because this person based in the UK is conducting some research in other EU countries, where does the onus lie for appointing this EU representative? Is that with the client company in the US, or is it with the subcontractor in the UK?
It's with the data controller. Yeah, so the US company should be appointing the EU representative.
Okay. Another question on the EU representative. Do we need a representative if no personal information is gathered? PII is gathered?
No. So if that's your very first starting point, if there's no personal data involved, GDPR doesn't apply to that processing. Okay. So then everything falls away. The principles fall away, the obligation to appoint the representative falls away. If there is no personal data, and again, it's a very wide definition of personal data, so make sure that you're, maybe not interpreting it too narrowly, because it is a broad definition of personal data. But if personal data is not included, then GDPR falls away.
Okay. Really useful, thank you. Always get myself tangled up with the rules if a B2B client wants to give us a customer list for research. Does the customer need to be advised in advance that this will happen, or can we do a study and tell them at the end who it was for?
So again, that comes down to the working out what other people are going to do with it, and so firstly, you need to, as I say, you need to be really upfront about what you're going to be doing with it. So when you're collecting the data, if you know that A, B, and C are going to happen with the data, you need to be upfront about A, B, and C when you're collecting the data. Or you'd have to go back to them at the end and say, are you happy? You know, do you consent to us sharing this data with X, Y, Z? You can do that. It's just a two-step process. You can't just assume that people will be happy for you to do it. And then the other thing is just to really think about, you know, what are the lawful grounds on the step A, B, and C. So if you're providing that data to the end client and they are planning to do something that requires consent, so maybe send them email marketing or share it with another third party, then they would need to be named, and that consent would need to be obtained.
So I think the question that they're trying to understand there is whether if the client is giving them a list, does the client have to have got permission in advance that they will be doing research? Actually, it's mixing two things. And should, when they do the study, tell them at the end of the study who the research was for and hence who provide their contact details?
Yeah, so in the client's privacy notice, they should have said at the point of collection, we'll be using this data for market research. Now, you need to think about your lawful ground for that, because it could be legitimate interests. So you wouldn't necessarily need a tick box at the point of collection to say, yes, we consent to market research. That could be legitimate interests, okay? But again, you'd need to do that legitimate interest assessment form. Think about, you know, what, you know, again, if it's sensitive data, that's another issue. You need to bring that into the mix and think about you need to obtain explicit consent for any processing of sensitive data. So the answer is that as long as the client had it listed in their privacy notice at the point of collection, or has since obtained consent, or you know, or since, sorry, not obtained consent, advised people of a new purpose, so sent out a new privacy notice, which you can do. You know, you can write to them and write to clients and say, you know, we've got your data, we're thinking of doing this, we're doing this, we will be doing a series of market research projects, and we're going to be processing this data under legitimate interest. If you want to opt out, please let us know. So that's what you must do with legitimate interest. You must give the data subjects the right to opt out. So if your client hadn't been upfront at the point of collecting the data to say that's what they're going to do, they can reissue a new privacy notice and advise people of their right to opt out. So that's one way of dealing with that. And what was the second part of the question, sorry?
The other part was, if you get this data from the client and you carry out a study, do you have to tell the person that you've interviewed who the study was for at the end of it? Do you have to reveal the client to them?
So again, it depends what your it depends what your role is in that processing. So if you've satisfied yourself that you're a data processor, and you're merely following the specific processing instructions of your data controller, and you're not doing anything else with that data, then really it's all down to the client, the data controller, to have that relationship with the data subject and tell them what they're doing, etc. But if you're the data controller, then at the point that you're becoming the data, I mean, in what scenario would you be doing other things with the data? I'm not sure. That's maybe a question for you. You know, if there's an element of you being able to decide how to use that data, that's when you're a data controller. That's when you would have to give them your own privacy notice, and that's when you would need to tell them what you're planning on doing with that, you know, with that data. So if you are, you know, manipulating that data in some way, or producing a report, or whatever it might be, then that's where you would put that information in your privacy notice to tell people what you're doing. I mean, to be honest, I mean, let's think of the risks here. You know, I mean, the things that people are going to be, the things that people, we've got the letter of the law, and then we've got the risk. And I always like to think of the risk analysis. And you've got to think about the things that are going to annoy people. Okay, so if client A gives you a list of data of people, and you know, you treat them very nicely, and then at the end you say, oh well, this was a research product for you know, Coca-Cola Limited, would you be happy to be contacted to do another more in-depth interview by them, or by receiving some free products and testing? You know, if you're upfront with people all along the way and nothing out of the blue happens, then it's very unlikely for them to be a problem. Okay, if suddenly, you know, if you do some market research and suddenly they start getting spammed by someone that they have no interest in, you know, that's when you have to worry, and when problems, you know, start. So as long as you're treating the data respectfully and treating the data subject respectfully, then you shouldn't have an issue, even if you're not complying with the, you know, the nth degree of the law of data protection. So what I would say is just no nasty surprises for people. Okay, and if you're doing what they would reasonably expect with their data, then you should be absolutely fine.
Okay, so what are the rules with regards to sharing video clips of participants? Is it okay to say that the video clips will live for the life of the report?
Yes, that would be fine. Yeah.
Okay, it sounds very open-ended to me, but okay.
Well, for the life of the report being, I mean, yeah, I mean, I assume from that you know, that did have the time end of the report. I think there would be a time period frame around that. So yes, in that case, yes, I would absolutely put the time frame of the report around it. Yes.
Okay.
So yeah, I don't think anyone would expect that a report would be open for 10 years or something like that, because obviously it would lose its value. So, but yes, absolutely, if you can narrow that down to, you know, it's a 6-month review of the report or whatever, then yes, that's the shorter the time period, the better.
Okay. If clients share customer data for recruitment for market research, where the data has been collected on the basis of marketing to those customers, can it be shared for research recruitment on the basis of legitimate interest, assuming it passes a legitimate interest assessment?
Yes, so if it passes the legitimate interests assessment, and that is, so that if the processing that passes the legitimate interest assessment is the sharing, then yes, absolutely, it can be shared on the basis of legitimate interests. So that's the element of the processing that you're looking at, is the sharing of it. Yes.
Okay. Somebody here says, I recruit respondents for clients and currently store the data in Google Drive. Is that okay?
So I do believe, and I'm not in any way presenting myself as, I mean, there's so many different platforms out there. I'm not presenting myself on in any way, you know, the authority on whether each of these platforms is 100% compliant. I would go onto Google Drive and look, or Google GDPR compliance and Google Drive, or whatever platform it is that you're using, and satisfy yourself as to the security of it. But yes, I certainly have most of my stuff on there, so I'm happy with what I've read.
Okay, still more questions on the EU representative issue. If I'm given customer contacts in the EU and asked to interview them, can I still do that?
So again, it depends if you're the processor or not. If you're the processor, then the data controller will need to put that EU rep in place if they don't have an establishment over there. So you might want to ask that question, whether they do or not. But if you're the data controller and you are processing the data of people within the EU and you don't have an establishment there, then you would need to put an EU representative in place.
Just another question on that one. Does it need to have to be a lawyer, the representative, or can it be any person?
No. I mean, a lot of them are, because you do have to have a good knowledge of GDPR, and there's also liability issues as well for the representative. So a lot of law firms do offer the service, but I think I have seen people spring up who are just taking advantage of the opportunity. And I would say that when you're looking for the right representative to go to, do your due diligence and don't just go for the cheapest one that's sprung up overnight. You know, that probably take your money and not be of much use when an issue does arise. So I would look into that carefully. Obviously, lawyers are highly regulated, so probably, you know, they're going to be much more, my view anyway, much more let's say I would trust lawyers much more than I would trust, somebody who's just popped up their website a couple of weeks ago and claiming to be a data protection expert and offering these services.
Okay, just noticed that somebody else asked the same question. So I have clients in the EU, but conduct the research in the UK on their behalf. Do I need an EU representative?
Just the client is in the EU, not the data subjects.
Yeah.
No. So if your client's in the EU and they're the data controller and they don't have an establishment in the UK, then they would need a UK representative. Okay. If you're the data controller and you're working with the UK and you're based in the UK and you're working with data subjects in the UK, then obviously you would not need to appoint a UK representative, nor would you need to appoint an EU representative just specifically on those facts you've outlined. Obviously, you might have other projects that might necessitate that, but the pure fact that you've got one EU client in, one client in the EU does not necessitate an EU representative.
Okay. Can Suzanne give guidance on where market research has some privileges under data protection law, as I understand was the case, and which is one of the reasons we abide by the MRS Code of Conduct, etc.?
Well, in terms of email marketing, the main sort of thing there is that if it is really for market research purposes, then it falls outside the usual rules on email marketing. Is that what this person is referring to?
Yes, I'm not sure. I haven't heard about these privileges before, but there seems to be some term of because we abide by the MRS Code of Conduct. I don't know. I can't really, without more information from the question. The person
well, I imagine it's around that, because there are. I think that people often try to get around the email marketing rules where a consent is required by trying to phrase the email marketing as market research, but it has to be. It has to be bona fide market research to actually benefit from falling outside of those requirements as to consent.
Okay. Where can I find the new wording for UK versus EU separation, or to include, excuse me, in privacy notices and contracts?
Well, you could Google it, or you could buy my template package. It's fairly long, so I can't really, sort of off the top of my head, tell you what it is. But yes, there is obviously the new UK GDPR. So we now have two GDPRs. There's the UK GDPR and there's the EU GDPR. Fortunately, they're both very similar, although slightly different. And so yes, we just need to make sure we're referring to the right regulations within our privacy notices.
Okay. If a client has sent out revised privacy notices to customers to say data may be used to invite them to participate in research and giving them the opportunity to opt out, do you still need to do a legitimate interest assessment, or is consent then the grounds for data processing?
Well, you need to work out the lawful grounds of interest for the client before you would send that privacy notice out. If that's your aim, then you need to work out the data flow and the lawful grounds for processing that data before you send that privacy notice out. And if you've worked out that you can rely on legitimate interests, then that's when you would send that privacy notice out, talking about what you're going to be doing with the data, that the lawful grounds of processing is legitimate interests and giving them the right to opt out. Obviously, if you decided that the lawful ground is consent, then you would be communicating that instead and getting them to tick a box to indicate consent. So make sure you exercise before you, exercise of working out your lawful grounds of processing for each of the data flows before you go out to the data subjects.
So that would be the client who would need to do that to define whether it's legitimate interest or consent in that case.
Yes,
if they're sending out the revised privacy notice.
Yes, if they're the data controller, yes, they would need to do that exercise. Yeah.
Okay.
I'm afraid I've only got a few more minutes. So final questions, I'm afraid, because I was told it would only be 45 minutes. So I've got another call at 15:15.
Okay, just one last question about your book. So somebody's noticed that your book for Dummies is dated November 2019. Is there a more up-to-date post-Brexit edition? And how would we best access your advice on those changes apart from today's post-Brexit?
Yeah, so the book is, you're absolutely right, 2019. So what it doesn't include is the changes to international transfers. So the transfers to the US, obviously the Privacy Shield has been invalidated. That's not covered in the book. We do have lots of sections about, because obviously we were anticipating what would happen with Brexit. So that is covered quite thoroughly in the book, and talks about what will happen if there's a deal or no deal, and if we get adequacy, etc. But if in the book there is a, I think, I can't remember where it is exactly, but there's a link that sends you to an opt-in page where you can get on my GDPR update list. And that gives you pretty much weekly emails about updates on GDPR, but also invites you to trainings where there is significant, well, we do trainings on all sorts, but obviously covers the significant changes. So we did obviously a training webinar on the invalidation of the Privacy Shield. We've done a training on EU representatives. We've done about 4 on Brexit, and you know, we have an ongoing schedule of trainings. So the links in the book, can't locate it off the top of my head right now. In fact, I think it's SuzanneDibble.com/GDPR updates, I believe, is the link. So if you sign up there, then you'll get added to my list and you'll get our GDPR updates and get invited to the trainings.
Fantastic. Thank you so much, Suzanne. That has been really, really useful. I think the number of questions just demonstrate how much interest there is in this topic. So I think that's been very useful. Yeah, that's all we've got time for today. So yes, thanks, Suzanne. Thank you to everybody for listening in. I hope you found it useful too, and have a lovely afternoon, everyone.